Please take your seat because we are going to start again.
Yep, sure. Okay. Good morning, everybody. After the very interesting speech and discussion with Mr. Letta, we might now go to nitty-gritty antitrust and on something which I think is which may be nevertheless interesting. First of all, let me thank Paolo for first organizing this incredible event. Every time I talk about Paolo, I say that he is a magician because in the last 20 years he has set up not only a very successful consultancy firm, but it has been this event, which has been on for many, many years, and it's becoming more and more interesting and complete. Actually, I must say, Patricia came here and said she was amazed by the program. She wanted to leave tomorrow, but she stayed until the end of the festival. Okay, so and this is shared by everybody. Now, I must thank Paolo also because in the last few years he has asked the Italian Antitrust Association to organize the opening session with teams which have been varying over time. And this time we thought appropriate to discuss, to tackle an issue which I also see in the programming of various sessions to be discussed, which is the development of private enforcement of competition law in Europe, but with something which adds value to this discussion, that we are discussing this together with representatives of antitrust association across Europe, which is also a consequence of a dialogue that we have, which has been going for a long time, but which is taking more form more recently. The authorities have the ECN, then it's not a bad idea if there is a dialogue between association of practitioners and economists of antitrust. The more so on the subject of private enforcement, because more than other streams of our of antitrust, private enforcement is very much still a national, governed by national rules, national judicial system, and so on. And so I think it is extremely, we thought it was extremely interesting to see what the developments are first of this practice. This is not necessarily the same in the various jurisdictions. And secondly, how this activity develops in the various jurisdictions. To discuss this, we have an exceptional panel made of representatives of the French Association, the French Association of Lawyers Practicing Competition, the Dutch Competition Law Association, the Spanish Association for the Defense of Competition, for la Defensa de la, and the German Lawyer Association, I don't dare say the name, but it's most famous association of all, which has been going, and finally by the Italian Antitrust Association. Mario Siragusa should have been with us, but he had a problem, but he is substituted, I'm sure, even very excellently by Matteo Beretta, who is a lawyer from Clerigotli, whom everybody knows, and who is a member of our association. Now let me introduce very briefly the speakers. Guillaume Abron is from Darrois. He's a lawyer in the competition field. He's a member of the French Association, as I mentioned. Uriel Klump is from Oppeland. He's also a lawyer, he's a Stuttgart. He's a lawyer practicing antitrust law. He is for many, many years. He speaks Italian, and he has spent a year at the Milan University during his law course. Morissette Schaufeli is Dutch. She practices in the Netherlands and in Belgium. She is the chairperson of the Dutch Association of Competition Lawyers, and she is from Nauta. Patricia Vidal-Martinez is from Uria. She is the chairman of the Spanish Association of Competition Lawyers, ex-former chairperson, past chairperson of the Spanish Association of Competition Lawyers. So very qualified, and Matteo Belletto we already introduced. We have, say, about 50 minutes to go into just a small survey and discussion on the issues on the different jurisdictions on private enforcement. We've thought to articulate these 50 minutes in first with a very brief introduction of national private enforcement systems. The systems are not necessarily the same. The judicial, as they are organized, as the discovery process goes on, how the evaluation is made of the damages or the effects of anti-competitive practices. So we go very briefly to illustrate. And we start with Morissette.
Hello, everyone. Thank you, Alberto, for inviting us to this wonderful event. And also from the Netherlands, the Competition Law Association is very, very happy to be able to participate in this sort of newly established, closer cooperation between the competition associations. Now, when it comes to private litigation, competition litigation, I believe that most of you know that the Netherlands is, well, in the Netherlands this is a very, very big thing. And there is so much to tell about competition litigation in the Netherlands, but I'll try to keep it brief. The Netherlands is and remains a very attractive forum for competition litigation. We see many follow-on cases based on one-on-one, one-on-two, and the DMA. And one of the first cases we expect to see a DMA angle is the ad tech case that was brought earlier this year by about 34 media companies that launched a claim against Google of about 2.1 billion. And they came from 17 different countries and sort of tried to work together and brought that claim in the Netherlands. It's formally based on 102, but we would expect that they will also use the DMA in their litigation. And perhaps when it comes to the DMA, it's also interesting to add that also the Dutch Competition Authority, the ACM, is very much in favor of using private litigation also as a tool to make the DMA as effective as possible. And they try also to encourage companies to use private litigation. However, all these cases also place a heavy burden on the Dutch courts, and they do struggle with limited resources. So what they try to do is to litigate as efficient as possible, and they try to organize the cases in different ways. For example, what we see, for example, in trucks is that cases are combined based on the topic. So if cases are more or less similar, they would try to combine these cases. Also, in most of the cases, what we see today is that the defendants are requested by the courts to work together and only submit one brief on behalf of all of them, which of course makes it for a judge much more efficient. From a procedural point of view, Also there, we try to be as efficient as possible, which means that very often cases are split. And then what you'll see in phase one, only the question of liability is addressed. And once the liability is established, the proceedings on damages start. And these two-step proceedings have many variations. You can also sort of split the case based on topic, evidence, etc. And each phase leads to an interim judgment. These interim judges can, of course, also be appealed. So, and that's perhaps a little bit the other side of the medal. It leads to lengthy proceedings. And we don't see that many final judgments in the Netherlands. What we do see, and that's probably also the consequence of these lengthy proceedings, is many settlements. So very often in the Netherlands, what you would see is a lengthy proceeding that is ultimately sort of finalized by a settlement. And also the courts in the Netherlands try to encourage parties, sometimes even referring to a specific interim judgment, to settle the case. I think I'll leave it there because there's so much to say, and I also want to leave time for some kind of discussion. But I say in conclusion, we have a quite flexible and open approach.
Flexibility, Maurice. One thing, if I understand, you have a section which operates in English and accepts English documents and so on.
Yes, so when it comes to competition litigation cases, we do not have specialized courts. We do have certain judges that over time have done so many cases that they become themselves a little bit more specialized in these cases. But there's also one court in the Netherlands that is working in English and where you can also submit briefs in English. At the same time, also for all the other courts, they would be open for the submission of English language documents.
Thank you. Thank you. We now go to Patricia Vidal, who will tell us about, is it open? Okay. Who will tell us about the situation in Spain. And one thing I would like to know is, we should probably from all of you, as Maricette already told us, is little bit how the judicial system works in this sense. We have specialized sections, not all the countries have specialized sections, which obviously poses a problem of perhaps forum shopping within within the jurisdiction about where it's more favorable. Thank you.
Thank you, Alberto, and thank you for the invitation. I'm also extremely proud to represent the Spanish Association, although I'm not the chairman anymore. It was a lot of work, to be honest, but I'm still profiting of that. That's the reason why I'm here, and I'm quite glad to share the time with you. Well, I think that Spain has become the big issue in antitrust litigation in Europe. Nobody thought that Spain could be an attractive place 10 years ago. And now, my dear Morissette, we have, and I just saw these statistics, about 16,000 judgments within 5 years, okay? So, we were the last of the queue, now we're in the top of the hill. Spain, I think we have suffered and lived, it's not suffered, it's an experience, all kinds of preliminary rulings. You can look at, 7 at least preliminary rulings. Everything has happened in Spain, from Sumal. Can you sue the affiliate not involved in infringement for the infringement of the parent company in Spain? Yes, you can do it. So now it opens Pandora's box, for instance, for foreign shopping. It has gone so far that, and I think some Italian lawyers here might know it, there is a case which is the litigation that is brought by CCS in Spain, and it's a case about a cartel in Italy, the carton board cartel, corrugated carton, that is brought to Spain. So competition also works for litigation forum, so now we are competing against the Netherlands. I'm not saying it's good, because our judges, well, they go very fast, as you can see. In first instance, in mass litigation, because we're talking about mass litigation, they do not accumulate cases as you do. That's why we have 16,000 rulings. So we have the same firm representing thousands of claimants with the same claim, with the same economic report, filing parallel claims. And the same parallel case is dealt with by about 75 different judges, because we have commercial judges, commercial courts, which are specialized courts, but there are 75. So for the same case, you have, in first instance, one judge saying that the claim is time barred. In the neighbor place, they say it's not time barred, it's 5%, they jump into judicial estimate, and in the next one, they say 15%. Same case, same cartel, same claimant as a law firm, and same defendant. So it's a bit difficult, just the coordination, but it's very, and I think it's something fair to say nowadays, at least in mass litigation, it's very claimant friendly. So that's why claims are coming into Spain, because it's fast, it's better place for a claimant, and it's not expensive. Nothing comparable with the UK, I don't know, with the Netherlands. We have not exchanged sensitive information yet about that, but well, definitely is a place to go as a claimant. And maybe another couple of things that I think interesting. In what regards procedure, I mean, this procedure is so fast because the claimant has to submit with a claim also all the evidence it wants to bring into the case. So the economic report has to be brought together with the claim. And the defendant has 20 days to respond to the claim. Of course, this is a heart attack for all foreigners. Also for nationals, it's a heart attack when you have, 30, 40 claims per week. But that's how it was. You have 20 days, you find out ways to stop the clock, but this is 20 days. And within 8 months, you have preliminary hearings with your own report, and then trial. Trials that can last 1 hour and a half, 2 hours. This gives you, and I'm not criticizing because our poor judges are flooded with thousands of cases, but this shows a bit the kind of sometimes poor quality judgments that you have. You have a judgment in the trucks case, I live it, and you had a case for DAF, and then all the mentions were for Volvo, or you had for Volvo, and the mentions were made to Daimler. So this is a copy-paste, basically, many times. This is for mass litigation. For individual claims, not large and mass litigation, the quality improves a lot. And also, we have seen that our judges are learning. This is evolution. 3 years ago, you talk about an econometric regression, and their eyes open like this, like, what are you talking about? Now they can discuss about the variable of control, about cost, about R2 square, and I mean, of course, judges learn, the quality of the rulings improve. They now start getting into the deeps of the economic reports. So I think we have a strong market in the future as litigators, let's put it that way. It's a challenge for everyone, but definitely many things to say. I think we have experienced all kind of issues so far. I'll leave it here because I could be talking for hours.
Patricia? Yes. Now I'll ask Kurti to provide us a brief overview of the German system, which I understand is the older in this in Europe in this kind.
Hello, everybody. Thank you very much, Alberto, for being here. I'm also very proud to share the German view on private antitrust litigation with you. Yes, Germany has a long-standing tradition in antitrust litigation. In the past, in the last century, cases dealt with refusal to supply or discrimination by dominant undertakings. The landscape changed significantly with the emergence of damage claims in the early 2000s. There are two significant changes in law introduced by the legislator. In 2005, the German legislator significantly simplified the assertion of antitrust damage claims. For example, he ordered the binding effect of decisions taken by the antitrust authorities. There's now a great deal of case law regarding the legal situation from 2005 onwards. In Germany, we have a three-tier court system. This is interesting because it's maybe a little bit different from other countries. We have regional courts, then higher regional courts, and the Federal Court of Justice. We have specialized chambers for cartel cases. However, due to our federal system, there's not one central cartel court with jurisdiction for the whole of Germany, but specialized courts in each federal state. This means different courts can try out different solutions. In the end, everything comes together at the level of the Federal Court of Justice. And I think that this system, different lower courts trying different approaches, enables the system to learn quite quickly. A question we as lawyers are asked quite often, and maybe you would ask me, how long do damages proceedings take in Germany? Yeah, it's difficult to answer. As a rule of thumb, I would say 1 to 3 years in first instance and further 2 years for every instance that follows. But there were also proceedings which took even more time. But I think the proceedings tend to get shorter because many questions now have been clarified by the highest courts. Therefore, the courts come quickly to the question of estimating damages. I think we will discuss this later. For successful action, you need evidence. Therefore, let me say some words on evidence. Traditionally, we do not have discovery or even pre-trial discovery in Germany. In principle, in German civil proceedings, I think as in other countries, each party has to present and prove the facts that are favorable to them. But the legislator, with the implementation of the damage directive in 2017, introduced a right to information which applies to all actions brought after the end of 2016. And this is interesting because the right to information can also be asserted before an action is brought. The right to information is directed not only against the participant of the cartel, but to anyone. Therefore, this is a really new tool. There are some restrictions. You cannot ask for leniency declarations or for settlement documents. And there are also rules how to deal with trade secrets, who has to pay for the cost, and so on. Therefore, in short, you can say we now have a very detailed system of disclosure, which is already being used, but details are, as always, still discussed, so courts have to clarify some issues here. I leave it there. Thank you.
Thank you very much. Thank you very much indeed. Guillaume, I think there are a few issues which have come out: discovery, the timing of the procedure, an issue that we have in Italy, the availability of judges, and therefore the duration of procedure. So how is it in France?
First of all, thank you very much, Alberto, and to the Italian Association for organizing this event and inviting us all. It's a pleasure to be here. So in France, private enforcement has existed for a year as well. It did not wait the EU directive to be launched, but it's true that it quite dramatically developed in let's say the last 10 years. And we see that also as lawyers in the Paris, in the competition bar in Paris. I think it clearly evolved, and it takes a much larger part of our work than it used to be 10 years ago. In France, we have a system of specialized courts for commercial courts, at least. Not a single specialized court at the first instance level, but there are 8 commercial courts around France, out of the more than 100 commercial courts that exist for all normal case, let's say. That have, so 8 commercial courts that have exclusive jurisdiction on competition law related matters. And within at least some of them, including Paris, there is a specialized chamber within the commercial court. And importantly, at the appeal level, there is an exclusive court for all appeals. So the Paris Court of Appeal has exclusive jurisdiction in appeal, and obviously the Supreme Court above it. And there is now quite a lot of case law, including up to the Supreme Court. So that's also a bit like you mentioned, Ulrich, in Germany, that brings some clarity on various topics on law. So we start having quite a significant body of case law. I should also mention the significant role of thank you, Matt, of administrative tribunals, which is completely different bodies of tribunals on the side of the private and commercial courts, because there are quite many claims brought by victims of anti-competitive practice that are public bodies, and so and it's completely independent. There is a different Supreme Court for this administrative court, so it runs in parallel, and it's quite important in the French system. In terms of timing, as in Germany and as everywhere, I guess it's difficult to mention a typical duration, because it varies a lot depending on the complexity of the case, on the availability of evidence, of the number of, let's say, procedural incidents that can be raised by defendants, etc. And the timing is also biased by, if you take the timing between first summons and judgment, in many cases it's biased by many stays. Cases are often stayed until appeal against the competition authority decision, and during the stay nothing happens actually. But I mean, if I try to, with all these caveats, mention a timing, I would say that before commercial court, in first instance, it will typically require more than 2 years, I would say, except in exceptional circumstances, but it can last much longer if there are many defendants, many incidents, etc., etc. For instance, in the drug cartels, and I think it's a very big difference compared to Spain, for instance. I mean, I think it's a good case to compare Europe, because there are cases all around Europe on the drug cartels. In France, to date, there are only a very few judgments that were issued at first instance level. And at this stage, and they have systematically dismissed the claimants and the claims. As my firm is is defending a case, I think it's quite good in this case, but it's an indication of something possibly. And for instance, there was in that case a high number of summons filed in the summer of 2021, because it was a time where the claims would have risked being time barred right after. And for all the summons which dated back for more than 3 years ago, there are no judgments yet, and they are not expected before sometime next year probably. So that's an indication of the fact that it can be of the duration it can take. And in terms of organization, I will finish on that, of proceeding organization. It's quite flexible. The courts and the judges are quite free to organize the proceedings. So it does happen that, a bit like you described, Maurice, in the Netherlands, it does happen that pleadings and sometimes rulings as well are split between first all procedural questions, and then perhaps on the substance between first liability and finally the amount of damages. It does happen, especially in big cases, but it's clearly not systematic. it's still a minority of cases, I would say, and I can leave it here.
Many thanks, Guillaume. And many thanks, Guillaume, and thanks, Alberto, for inviting me. So let me start with this mission impossible to summarize the key features of the Italian private enforcement in a few minutes. The first one is that private enforcement in Italy falls within the exclusive jurisdiction of a few specialized sections of the Milan, Rome, and Naples civil courts, centralizing all the antitrust civil actions before a few courts is certainly a welcome decision, as it creates a valuable expertise within a limited number of courts and judges. However, this decision, of course, results in a massive workload, especially if one considers that these courts are specialized not only in antitrust matters, but also on other areas such as IP rights, unfair competition, and commercial disputes. I should also add that the number of judges in these courts is very limited. As of today, 27 judges overall in Italy. Forum shopping. So far, Italy cannot be considered to be among the most attractive and appealing jurisdictions in Europe for antitrust private enforcement. This is confirmed by the fact that I'm actually not aware of any attempt to try to establish jurisdiction before an Italian court in connection with infringements which occurred outside of Italy. Rather, I'm aware of the opposite. So I knew about the rumors regarding the Spanish litigation in connection with our cartel in the carton board market. And I also know about the civil action brought by a client of these manufacturers of carton board before the Amsterdam Court of Appeal. It is actually one of the cases which triggered the reference for preliminary rulings to the European Court of Justice. Procedure and timing, generally speaking, 2 to 3 years for the first instance decision, generally speaking, a couple of years for the appeal. But if one is to ask me about the duration so far of antitrust private enforcement in Italy, well, the answer is significantly different because so far the duration of these actions have been much lengthier. Just to give you an example, the first action grounded on the Trax decision was filed in 2017. So far there is no yet final decision by the Court of First Instance of Milan. So, nature of violation. In Italy, almost all private litigation is follow-on litigation, almost all regarding Article 101 infringements, cartels, although there have been, of course, also standalone cases and also cases regarding Article 102 infringements. So, the current stage of development of private enforcement in Italy, we are very far from the numbers we hear from the Netherlands, from Spain, but still following the implementation of the damage directive, we have experienced a significant increase in follow-on cases. And this development was largely fueled by 2 decisions, which have already been mentioned by many of you. The carton board decision by the Italian authority in 2019 and the Trax decision by the Commission in 2016. Considering the products involved, the market share of the companies involved in these cartels, or alleged cartels, the temporal scope of these infringements, the number of potential claimants is huge. There are no official numbers, but the private enforcement concerning these 2 cases is, in my opinion, well above 100 cases in Italy. So still very far from your figures, but quite promising.
Thank you, Matteo. One issue which we have in Italy, but I think we have everywhere, obviously, is damage estimation and the role of the judge and the role of outside experts. This issue in Italy is particularly relevant. I may anticipate that we are organizing as association a discussion about the role of court-appointed experts and private experts. I hope sometimes in November. But while we wait for that, I would like also to know from our panelists how it works in your jurisdiction. Do you use experts? Is the judge more autonomous? How is evidence collected and evaluated? Thank you.
Thank you. So, as I explained in my introduction, cases are very often split, which means that the actual calculation of damages is typically very late in the process, like when you already established liability. Typically, you would see that both the defendant and the claimant have appointed an expert, and those expert reports are submitted to the courts and often used. The Dutch judges have a lot of flexibility on what to do. They can determine evidence as they wish. They can also determine the damages as they see fit. So they can either base or estimate their sort of calculation of damages based on these two expert reports, but they're also able to appoint their own expert. But in practice, that doesn't happen very often because at least Dutch courts believe in the adagium that, one other economic reports leads to even more point of views, and that perhaps even complicates the discussion even further. So it's not typically very helpful to appoint your own expert. In practice, if they do appoint their own expert, it means that also parties have a say in that. They can express their views, both on the appointment on the expert, the questions that are raised, the report that the expert sort of submits. So then also it sort of adds to the sort of very lengthy proceedings. So that's, I'll give it to you.
Yes, in Germany, the situation is as follows. We have a strong presumption that there was a damage developed by the courts, and now we have it in the law. But the presumption does not help as regards the amount of damage. When it comes to the amount of damage, the German civil procedure law provides that the judge who must decide on the amount has the option to estimate. He's quite free. He can ask a court-appointed expert for help. He does not have to do it. And as I said earlier, the advantage of our federal system is that different courts can try out different approaches. And I think when it comes to estimation of damages, we can see three different approaches today. First, there are many courts that appoint their own expert to give an opinion on both the question of a damage at the merits and the quantum of the damage. This takes some time because you have to find the expert and so on. Therefore, there are other courts that apply a very rough thumb themselves without outside economic advice. For example, the Dortmund Regional Court in individual cases did so. They call it the broad X approach. And then there are courts that deal in depth with economic issues and with expert opinions prepared by their parties' economists. The judge is the one who calculates or estimates. For example, the Berlin Regional Court last year awarded damages of 18 million to some of the plaintiffs in the elevator case following its own detailed analysis without recourse to a court-appointed expert, but on the basis of the considerations in the plaintiff's expert opinion. So we have different solutions, and the question is, what does the Federal Court of Justice do? They go not so far to require a court-appointed expert in every case. However, we see it from the most recent judgment that the Federal Court of Justice considered the involvement of a court-appointed expert to be appropriate, and they also commented on the economic methods to be applied and made clear that a regression analysis is in any case a suitable method for estimating the damage.
Thank you very much indeed. Now, Patricia, is up to you, and I know it's a little bit different.
Okay, this is a real challenge when I told you that we have 75 different judges of first instance, each one saying something different to go into the economics, but I'll try. Well, first thing, we have to differentiate cartel cases from other cases. Okay, there's life beyond trucks, basically, and I think you mentioned the DMA, etc., abuses of dominant position. That's another world. We will start seeing it. I'm representing some cases as defendant, and the degree of depth of economic analysis has nothing to do. Okay, margin squeeze or exploitative abuses, that's another world, different kind of evidence. But for what is cartels, we, as in Germany, what judges built up a very strong presumption of damage in cases of cartels, even before the damage directive was in place. So at the beginning, it was an ex-re ipsa issue. Now it's, well, why have you been doing this for 14 years? It was, you know, to get some extra price. Basically, that's the main reasoning. So starting from a hard presumption of damage, what we have seen is that our courts, which are not, I mean, theoretically they can appoint a court expert, but never do it. They have never done it. They try to rely on the reports of the parties. And what you find there is that the level of proof that has been asked for plaintiffs, at least for these first years, it has been very, very low. We see economic reports which were basically quoting Oxera's report of 2009, meta-studies, I mean, not even adapted to the case. And, well, the court thought, well, this is reliable, there's no harm, this is enough. So they just jumped into the judicial estimate. So what it should be an exception, which is the judicial estimate, is now the general rule. The thing is that this is evolving little by little, and now we see that courts start looking also at the defendant's reports, which so far it was something, I'm not going to say ignored, but simply they were not understood. And if you say there's a very low damage, they simply don't trust it, so they just jump into the judicial estimate. That's the point. Now they start looking at the defendant's reports, and if the defendant report provides an alternative estimate in cartel cases, they are willing to analyze that alternative estimate. And we are starting seeing from trucks, now we have cars, that's a national cartel case, and we see judges understanding the economic evidence much better than in trucks. And they are seeing plaintiff's reports, which are based in meta-studies, very, very low quality reports that they should be dismissed. Then they look at the defendant's report, and on those bases, if they provide an alternative quantification, sometimes they are admitted. If no, we see a tendency to go in all cases to 5%. I mean, I usually act as defendant, and sometimes I see rulings like, well, like in a trucks case, here we have the same blah, blah, and this is not a trucks case. This is the milk case, or this is the cars case. So just to summarize, no appointed expert by the court, and they usually go into the judicial estimate. Maybe one thing that is important, because I think it's exceptional for Spain, many courts ask the competition authority to intervene as arbitrator or as someone to rely on in order to determine the amount of damages. And of course, the role of the competition authority is not to quantify damages. What it did was to issue guidelines, and I invite you all, because they're also in English. They are in the official website of the competition authority. A guideline addressed to judges, addressed to economists, and addressed to lawyers. And it makes things that look like science fiction, they look understandable. So when they talk about an R square R or the variables of control, it's something you can read. There, the association, and of course, that's my last point, we intervene heavily, and I think we improved a lot at guidelines, because I mean, now it has a glossary, like for dummies, the glossary for dummies. Many explanations for non-economists. So it was needed, actually. If you see that judges are going into judicial estimate, they need this guidance. And I'll stop here.
So in France, so first of all, there are also some kind of guidelines, practical sheets that are published and updated sometimes, and that were really recently updated, that are done by the Paris Court of Appeal, but with a pool of experts, based on works from a pool of experts, professors of law, lawyers, economists, and they are pretty useful and used by judges actually, and also parties. And they're also available in English, so I mean, it could be a good reference if you also, so Spanish and French guidelines. It would be interesting to compare them actually, which I have not done. In terms of estimation of damages, and first, whether courts appoint their own expert or not. First of all, it's important to mention that there is a Supreme Court judgment that prohibits the courts to exclusively rely on a party expertise, on a single party expertise, to assess the amount of damages. So that means that judges, I mean, they adapt to this ruling, but they have somehow to be at minimum critical or to add some extra evidence, even if they want to rule completely for the claimant. Then courts have very different practices in terms of appointing experts. For instance, at the Paris Commercial Court, there is no court-appointed expert. At least recently, it's actually a policy of the court to require the parties, and in particular the claimant, to do their jobs themselves with their own expert reports, which the court will then review, criticize, etc., but itself. So that's quite a clear policy at the Paris Commercial Court. At the level of the Paris Court of Appeal in the second instance, it's actually rather the opposite. We see a frequent recourse to court-appointed experts, and this is sometimes actually criticized as being a bit too systematic and resulting in having the judges somehow discharging its own duties because they would entirely rely on the expert on the the final and probably maybe not the most important part, but at least the final part of that judgment. Now, in terms of judicial estimate, it's not really something, to my knowledge, that French courts will use, at least as such. There is a principle in the French law that prohibits judges from awarding lump sum damages, so it needs, in theory at least, to be the actual quantification of the actual damages. I guess it's a universal principle, actually. But it has to be mentioned that we do see sometimes judgments where parties' estimates of damages are very roughly criticized and corrected by the judge with very limited justification and sometimes not really apparent sound basis. And that leads to estimates that are not called judicial estimates, but could look like it. And also, importantly, I don't know if it's something that is the case in other jurisdictions, but there is a possibility for the judge to award moral damages, non-pecuniary damages, which, again, it's not judiciary estimate, but sometimes it looked a bit like this. So, for instance, the amount is quite exceptional, but in a case, in a quite recent case, the Court of Appeal quashed the award in the first instance judgment of 260,000 euros of pecuniary damages for a price of a charge, but it confirmed the award of 200,000 euros of moral damages awarded to, I quote, compensate for the market disturbance caused by the practices. So that the amount is exceptional for moral damages, but it shows that there is kind of a margin when the judge thinks that the pecuniary damage is not very well established. It has another room open to give some compensation. And I think we are running out of time, so we'll leave it here.
Thanks, Guillaume. So Italy. In Italy, damage quantification is systematically devolved to independent experts, which are appointed by courts either on their own motion or upon request by the parties. These experts are instructed to answer to a set of questions set out by the court after consultation with the parties that include economic and econometric analysis to estimate the body overcharge and the pass-on rates. Party usually also appoint their own experts. Courts retain full discretion whether or not to ground their judgments on the findings of the experts and may still opt to assess damages based on equitable principles. For example, in 2021, the Naples court, in a follow-on case concerning, once again, the trucks case, following the technical expert opinion in which the expert concluded it was not possible to estimate properly the surcharge, decided to award the damages based on equitable principles in the range of 15%. A final note regarding independent expert. There is currently a general perception, certainly among the Italian legal community, that the number of experts, we have here a champion, a national champion, Paolo, available in Italy with the required expertise and skills may not be adequate to address the increasing number of cases, and this shortage of expertise might affect going forward the quality of the technical support that the Italian courts need. To date, there are no available estimates regarding the quantum of damages awarded by Italian courts in cases concerning cartels. In addition, technical experts have provided overcharge estimates, but these are really very case-specific, and therefore they cannot be considered representative of a very specific or particular trend. Things might change in the near future when a number of judgments will be released in the pending cases regarding mainly the carton board cartel case.
Okay, thank you very much, Matteo. The last point you touched must be the reason why we have more and more consultancies which are becoming members of the association. Now, we have started late, so we want to say, but there is a question, and so I want to, okay.
Thank you very much. My name is Balin Bassola. I'm from Hungary, and my law firm, we are involved in several litigations in Hungary. You may know that in Hungary, you have a presumption of an overcharge of 10%, which makes Hungary an attractive forum. Always when I appear before the court, I have a lot of fun arguing about different legal arguments and opposing the defendant's ideas and so on. But I always ask myself the question, and while I was listening to you, I was doing the same. Is this an efficient system? Is it efficient to litigate for 5, 6, 7 years and perhaps lose in a case where you are convinced that there was an overcharge due to a cartel? Do we need an absolutely radical shift in this system? What came to my mind, and perhaps I would be happy to listen to your reflections, is could, for example, and there are some ideas in the US, I think, or somewhere else, could the competition authority, for example, order the establishment of some kind of fund from which those who have suffered the harm, undertakings or consumers and so on, could draw their financial damages? So do we need a radical change? What do you think? Do you have something on mind about this? Thank you very much.
Well, some of people want to give this opinion. We were talking about it earlier.
Well, I think that what we are living, I mean, these first years of mass litigation, that I agree, at least in Spain, is not efficient at all. There are many different aspects why it's not efficient. Yeah. And I can discuss it later. But what is true is that these were cases that were based on exchanges of information. Okay? So it's not clear-cut cartel cases, traditional ones. You might discuss tracks or not. I'm involved, so I'm not going to say anything, but it's not the kind of many cartels. I've been a leniency applicant, okay? I've seen everything. Not guns, but everything. This is not a classical one. And then we move into cars, Spain, for instance, and it's an exchange of information, not even about prices, okay? And then you go to the milk case, it's again a exchange of information, blah, blah, blah. So what I'm saying, to the extent that the first cases were, referred to not traditional hardcore cartels, they were named cartels, but of course defendants wanted to fight against it. If you find a case of market sharing, price fixing, etc., I see the point. I mean, there's a damage, yes, and we should establish a system. At least in Spain, what you see first is a lot of settlement in those cases. Secondly, even the competition law establishes as a mechanism to reduce the amount of the fine, the possibility to establish a fund. So it's within the infringement proceeding that you can take it into consideration. Has it ever been applied? No, but I think it's an extreme good way to do it, because you reduce the fine, you can also settle very early, you don't waste your client's resources. But I mean, I think that what we have lived is because of the kind of cartels. Maybe in the future this changes.
Two short comments. We had discussion in Germany to introduce a rule similar to the rule you have in Hungary, but at the end the legislator did not decide to introduce such a presumption. And I think this is correct, because we have information exchange cartels where there was no effect, but we have a decision, and there are institutional plaintiffs who try to make money, and therefore I think it's not fair to have this presumption, because it's very difficult to rebut this presumption. Second comment, what we have seen that in public contracts you have now contractual clauses introducing such presumption, and the state, I think, is obliged to have such clauses. Therefore, if the state or the region or a city is affected by a cartel, they invoke this clause, and then the cartelist has to prove that there was no damage or lower damage, whatever.
Thank you very much to everybody. Thank you for the question. It will be interesting to go on a little while, because we also had other themes, and even what you suggested makes me think about some practices of the competition authority about determining sanctions according to some commitments that the parties may have about restoring damages. That's something which we have criticized, but probably wrongly. And, but there are so many things interesting in the program that we may stop here. Thank you very much.